What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Monday, July 14th. We are going to go over Judge Boreski's order regarding Lori's medical records, and also Lori has filed another handwritten motion for a new trial, and we're going to go through all that. Let's start with the judge's order. It says the court has received and reviewed the state's motion for defendant's correctional health services records filed June 24th, 2025, as well as the defendant's objection to state's motion for defendant's correctional health service records filed July 10th. The defendant put her medical condition at issue by claiming she was too sick to proceed with trial. Contrary to the court's findings that there were no objective medical evidence to support the defendant's claim that she was medically unable to proceed to trial. The defendant also interjected a specific diagnosis into some of her pleadings for which there was no evidence other than the defendant's statements. By peppering various pleadings with her alleged illness and medical diagnosis, as well as other references to her illness, she also disclosed otherwise protected information to third parties and the public, thereby partially waiving patient medical professional privileges. It is ordered granting the state's motion and directing correctional health services to disclose to the state copies of the defendant's medical records for all services, assessments, testing, and treatment provided to the defendant, limited to the time period of May 30th through no later than June 13th, 2025. CHS shall provide the records to the state within 5 business days of the filing of this order. So that's that. All right, moving on to Lori's newest handwritten motion for a new trial. I have looked up some of the things she has cited. A couple of things don't look to be correct as far as what she cited in her argument, one being something about land development. But here we go. The defendant, Lori N. Daybell, respectfully requests this court to grant the defendant's motion for new trial. There is a violation to the USCA Constitutional Amendment 4th for violation of medical evaluation, lack of impartiality, and abuse of discretion. Number 1, denial of Rule 15.5 hearing. So I looked up these things she cited, and Rule 15.5, that's a hearing which deals with disclosure rules, identifying outstanding issues with discovery or evidence, and it allows a judge to set deadlines for witness lists, exhibits, motions in limine, or late disclosure. I've had a lot of people lately inbox and ask, what is a motion in limine? Well, that's a pretrial request asking the court to exclude certain evidence from being introduced at trial. Moving on, number 2, not releasing the jury from the admonition on the record, and number 3, allowing gunshot residue and DNA evidence without sufficient foundation and denial of right to confront witnesses. Thus, violations of due process, the Brady Rule, which deals with exculpatory evidence, and she cites the Fry Rule, which is a legal test to determine whether scientific evidence is admissible in court. She also cites ARS 37-2083 Bill of Rights. From everything I have found online, this actually deals with public land. She could have been referencing something else, but you can let me know if I'm wrong or if you know what she was citing here. She also cites USCA Constitution Amendment 5, which is due process. She also cites 6, which is a confrontation clause that you can confront and cross-examine witnesses against you, and you have subpoena power. She also cites 14, that is a due process clause. She cites USCA Court Article 1(6) CL2. I think this is another mistake because from everything I have researched, this deals with members of Congress and prevents conflicts of interest, separation of power, or dual office holding. She goes on to say a violation of Federal Rules of Evidence 702. Rule 702 is testimony by expert witness. And in the law, it says a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. B, the testimony is based on sufficient facts or data. C, the testimony is the product of reliable principles and methods. And D, the expert's opinion reflects a reliable application of the principles and methods to the facts of the case. The last thing she cites here is download junk science violation, third law Strickland. The first part, the download junk science violation, that means that expert testimony fails to meet the standards of reliability. But in Strickland, there's no third law. It's a two-pronged test. So again, not sure if she messed up or I'm just not finding the right stuff online. In the state's response on pages 3, 4 to 6, and 9 to 10, Ms. Trina K acknowledges that the state is in possession of the defendant's medical, to which her colleague, Mr. Joseph Vigil, illegally obtained through the Maricopa County Sheriff's Office Jail Administration and CHS. Mr. Vigil produced on June 3, 2025. Mr. Vigil filed a response with the courts. Mr. Vigil did not obtain the results for the defendant's urinary tract infection because the test was sent to labs outside CHS and the Maricopa County Sheriff's Office. Therefore, the record is incomplete and incorrect, misdiagnosing the defendant's actual illness. On June 8th, CHS informed the defendant antibiotics were given for the treatment. On June 4th, Maricopa County Attorney's Office Civil Attorney Mr. Joseph Vigil presented the defendant's medical records and evaluation to the courts and the public. On page 10, Ms. K states, quote, "She had a viral infection and urinary tract infection," end quote. The judge ordered antibiotics. Therefore, Mr. Vigil misdiagnosis an incomplete record jeopardized the safety, well-being, deprived and violated my health, statutory and constitutional rights of the defendant. Mr. Vigil is not CHS civil attorney. Ms. Kimberly Chamberlain is. Because Mr. Vigil and Ms. K admit to obtaining the defendant's medical records from the Maricopa County Sheriff's Office Jail Administration, which Maricopa County Sheriff's Office admin gained through CHS by bypassing Ms. Chamberlain, who legally represents CHS and is obligated to obtain a consent, waiver, or court order to privileged patient-physician records, holds Mr. Vigil, Ms. K, the courts, the jail administration, and CHS in multiple violations. The discovery conflicts with the Bill of Rights in a direct manner. Then, due process as the supreme right, USCA Constitution Amendment 6. Well, what is that? I looked it up. This covers speedy trial, a public trial, an impartial jury, notice of accusation, the confrontation clause, defendants being able to subpoena witnesses to testify on their behalf, and the right to counsel. So I'm not sure which one of those. She cited Strickland earlier, and that established the standard for evaluating ineffective assistance of counsel claims, but I'm not sure if that's what she's doing here, because that would be herself. Moving on, the information sought includes interviews to which she is permitted as a matter of due process. The state and Mr. Vigil failed to produce to the court for an in-camera review. So I think for her, with her citing Amendment 6, it's either going to be the confrontation clause, which means the defendant has the right to face and cross-examine witnesses, or defendant can subpoena witnesses to testify on their behalf. The information sought includes interviews to which she is permitted as a matter of due process. The state and Mr. Vigil failed to produce to the court for an in-camera review. Mr. Vigil, on June 4th, read the defendant's medical records to the courts to which the public had access to obtain the results. The courts did not seal the medical files. Physician-patient privilege cannot be compelled. A patient can only waiver in writing or by consent or by court order. She cites ARS 32-2085. I looked that up. It says a psychologist-client privilege on the same footing as attorney-client privilege. The disclosure of medical records violates the defendant's right to the Confrontation Clause, USCA Constitution Amendment 6, and HIPAA. The court abused its discretion by allowing disclosure of the medical records and forcing the defendant to an evaluation. She cites more stuff from the Constitution. The Bill of Rights must yield to the federal and state constitutions mandate due process. Here she cites a Brady violation, Brady versus Maryland. That is where the prosecution withholds evidence that is favorable to the defense and material to guilt or punishment. This is a violation of the defendant's constitutional right to due process under the 5th and 14th Amendments. The state fails to produce justification of lack of impartiality. The defendant has FTR to support the fact finding and that the court supported the state's objections. FTR stands for the record, and that is a digital court recording software. And then in this filing, she cites the minute mark where her argument lies. The defendant was unable to admit exhibits as the state and the courts continued to state she would open the door to her prior convictions. She was denied sidebar, denied photos for presentation and cross-exam because the defendant's investigator was ill with the same symptoms as the defendant. And she cites exhibits to look at, which are attached to the motion as Exhibit 2. I do not have those, by the way. The next section, abuse of discretion, the denial of a Rule 15.5 hearing. Again, that deals with outstanding issues with discovery or evidence, and it also allows judges to set deadlines for witness lists, exhibits, the motions in limine, or late disclosure. The court denied requests stating that the defendant was not entitled to a probable cause hearing. The state asked the court to proceed with 2 aggravating factors. The legal sufficiency of an alleged aggravating circumstance allows a defendant to request a probable cause determination for alleged aggravators. The right to double jeopardy protection from subsequent prosecution on original charge. Again, she cites the Constitution Amendment 514, the Rules of Criminal Procedure, Rule 13.5B and C. What do those mean? Rule 13.5 says a judge can allow changes to the charges during trial if it doesn't add new or different crimes and doesn't harm the defendant's ability to defend themselves. Part C is fixing minor word issues or technical problems in the charge is allowed, and the court must allow it if it doesn't hurt the defendant's case. She also cites D, and that rule says a court may not reconsider an issue previously decided in the case except for good cause or as these rules provide otherwise. So in other words, once a court makes a decision, it's not going to backtrack. She also cites State versus Delgado and says Maricopa County denied and remanded. The court abused its discretion for late disclosure, Rule 15.7. What is 15.7? Arizona judges wide discretion to penalize parties who violate discovery rules, especially when it's done willfully or causes unfair prejudice. Tammy Latchick's testimony. The court abused its discretion for late disclosure. Because Ms. Latchick refused to testify during trial, the court allowed to present hearsay from Ms. Latchick's former colleague, Detective Pillar. The state presentation of expert testimony should have been excluded when expert testimony is offered as evidence. The district court acts as a gatekeeper, excluding junk science that does not meet standards of reliability. An expert testimony may properly be excluded if there is a danger of an analytical gap between data and opinion. She cites Rule 702, which is testimony by expert witnesses. Through expert testimony, proximate cause will not be established, but mere guess and conjecture. In General Electric Company versus Joyner, that was reversed and remanded. Nothing in Dauber or Fry rule or federal or state rules of evidence requires to admit opinion evidence that is connected to existing data, but the court didn't offer a check. The Fry rule or the Fry standard is a legal standard used to determine whether scientific or expert evidence is admissible in court. She also cites William versus the United States. Maricopa County expert credibility test in State versus Rojas. Maricopa County reversed and remanded. She then puts DNA sample and Fry rule. By allowing the gunshot residue and DNA evidence without sufficient foundation and the denial of the right to confront witnesses, Ms. Latchik on June 3rd in the middle of trial indicated she would not be testifying. The defendant objected to 2 forensic scientists testifying about the analysis that the report relied on the work conducted by Ms. Latchik, blood blot by Emmeline Espinoza, DNA swabs by Vanessa Malika, and gunshot residue by Kyle Mueller. Each expert testified, quote, collected by witness Ms. Latchik, end quote. But I was not present when the evidence was collected by Ms. Latchik. On page 8 of the state's response to motion for new trial, Detective Pillar, case agent, he observed Ms. Latchik collect the gunshot residue and DNA swab testing, then stated he was trained on how to collect this type of evidence. Detective Pillar is not a forensic technician, nor is this his expertise, establishing a mere guess and conjecture. His testimony on behalf of Ms. Latchik should have been excluded due to an analytical gap between data and opinion. And then she puts in quotes, junk science. The court abused its discretion by failing to inform the jury on the record and in court of the purpose that this is a separate proceeding and admonition. This alone supports the defendant's motion for a new trial. The legal rules governing the outcome of a case, admonition, which tend to be cautionary statements regarding the jury conduct, such as statements requiring the jury to disregard certain testimony. She cites James versus Kentucky. That's a case where procedural rules were misused to block a fair trial, especially when a court refused to give a jury instructions or allow evidence essential to the defense. Regarding James versus Kentucky, it was reversed, remanded, admonition violation, and she cites the USCA Constitution Amendment 5. And in that, I believe she is citing the due process clause. In the state's response, Ms. Trina K. avoided address the court's abuse of discretion in violation of admonition. Ms. K. failed to correct it within the courts. I'm reading this word for word, y'all, but here we go in the conclusion. Based on the above far finding, the state has failed to actual fact to support their claim. The state lacks justifications in all the above. The defendant request for motion for new trial should be granted based on bias, prejudice, abuse of discretion, and most importantly, the violation of admonition, which the state is desperately avoiding. So that is it for her filing. I really wanted to go in and try to look for these things that she's citing just to make it a little more clear. It was a little tedious, but I hope it helps you guys understand a bit more what she's arguing. And I plan to do that moving forward, is to look up and explain anything that's being cited in these filings, because otherwise it's just a word salad that makes no sense. I had somebody say it would be helpful if I did that, so thank you very much for that suggestion. We will see what happens. I have a sneaking suspicion it's going to be denied. Sentencing is in 11 days, July 25th, and then she has, I believe, 60 days to be taken back to Idaho to serve her 4 life sentences. If anything else comes up with this, I will let you know, but in the meantime, I hope you guys have a good rest of your evening, and we will see you soon.